All right, and then the next case, People v. Page, I did sign a remand order to the district court, so that's taken off the docket. And Mr. Clean, that would bring us to People v. Jason McCumbee. And that's file 25-6976FH.
Judge, can I approach real briefly?
Sure.
I just for the record, I'm handing the court. I just showed Mr. Goodrich. I'm just wanting to hand the court a few things Mr. McCumbee brought me today. I apologize for not having copies. I can make copies to make them part of the court file, but just for purposes of identification, I'm just simply going to hand the court some completion, some coursework he's done, some AA that he's done, just to kind of demonstrate to the court what he's been working on.
Very good. Thank you. All right, so Mr. Clayton, we're here for sentencing on in OWI 3rd.
Yes, sir.
In an attempt RNO, statutory maximums at 5 years and 1 year, guideline range at 0 to 6 months. Any additions, corrections, or scoring challenges from the defense?
No, sir.
Ms. Goodrich from the people?
No, Your Honor.
Mr. Clayton, go ahead with any, I have a requested forfeiture order from the prosecuting attorney. Does the defense have any objections to that?
We do not.
Okay, so we'll go ahead and sign that.
I thought we'd already signed the stipulated order, but I signed a lot of things every day, so I thought I had, but we discussed it. No, that's fine.
Okay, so I've signed that. Do you want me to give that to the clerk or turn that back to you, Mr. Rich? I don't remember.
I believe it goes to the clerk.
Okay. All right, Mr. Clayton, anything you want to say on behalf of the client?
Sorry, thank you, Honor. You know, I was trying to think about how I wanted to address the court on this. I've been in front of you a lot of times. You know that I try to look at both sides of the argument and try to anticipate what the other side's argument is going to be. And I completely understand. I think it's essential as an attorney to understand what the opposing side is. You know, so Ms. Goodrich and I, we talk a lot about our cases, and I understand that to a certain extent, to a large extent, she serves a different master. She's got a different job than mine, and that's how an adversarial system works, and that's fine. And we don't have to agree, and a lot of times we don't agree, but I can respect other opinions. What I want to share with the court today is my acknowledgement of the downside of Mr. McCumbee, the positives that he's making, and then the difficult balancing test this court's going to have to make. I think it is a difficult balancing test. And normally I wouldn't say, well, Jesus, a tough balancing test on a 0 to 6 guideline because they're going to be a sanction. How tough can it be?
No,
But
you're right, because my question in my mind was whether we should send him to prison or not, despite the guidelines.
right.
So yeah, you're right.
I mean, it's tough. It's tough, you know. And when the analysis is being done, I think it's important to look at. And I think I go back to the basics. What's the 4 goals of sentencing? You know, we all know them. It's, you know, it's not novel legal argument. You know, when I look at drunk driving cases, in my opinion, probably the biggest goal is protection of society, 100%. You know, because we get to all use the same roads. Why should I be in any kind of danger? Why should my family be in danger if somebody makes a decision to inhale chemical dust and drive a car? Why should that come on me? You know. But I also recognize that that's only one small aspect of it. The other aspect we consider is rehabilitative efforts, punishment, obviously, and deterrent effect to others. I tend to think that the deterrent effect to others doesn't really have a lot of impact. The reason being is that most people, if they saw the minimum sentence that the court is required to give of 30 days, that'd be a deterrent effect to anybody. Nobody wants to sit 30 days in jail. Nobody wants to sit 6 months in jail. Nobody wants to sit 18 months in prison. But I think there's a diminishing marginal return when it comes to how much time. What's that number? Okay. So when I look at drunk drivings, and I represent a lot of people accused of drunk driving, a lot of people convicted of drunk drivings, I think that probably the most important thing, they go hand in hand, I think it really does, the rehabilitative efforts of the court and the protection of society, how those marry, how do they merge, what's one trumps the other one. And I don't think in this case they need to. I don't think there is one trump in the other. I reflect back, and you know, this case has been going on for a while. Mr. McCumbee has made a lot of progress, but I remember I was leaving last year on a vacation, and as I was leaving, I got a phone call from Jason, and I've been trying to talk to him and say, hey, listen, you know, when are we gonna get serious about this? When are we get serious about, you know, your recovery? You've been through the sobriety court, you've been through treatment before. when's the light bulb gonna come on? And I had this conversation, Jason will remember this, with him many times. And he called me on, kind of out of the blue. He said, I'm ready. He said, I'm ready right now. He said, I've got a bed, Sunrise Center. I've got a plan. I'm gonna be there for a long time. And the court remember for a long time, when we did the hearings of Mr. McCombie's case, he was doing it from the inpatient treatment. And I think there was a little bit of guarded, maybe skepticism. Is he gonna stay? Will he actually follow through this time? You know, and but almost like clockwork, we do a jury status conference. Here's Jason at the center. Do another status conference. Here's Jason still at the center. Then he gets out. What's he doing now? He's doing his outpatient counseling through Harbor Hall here in Sheboygan. He's going to meetings. He's going to do everything he can to make himself a better person. All of that leads me to believe that there is great rehabilitative hope right now for Mr. McCombie. If he's rehabilitated, if he doesn't use drugs, if he doesn't inhale chemical dust, if he doesn't drink, everybody's safe. He's safe. He lives a long, happy life. We're safe because we use the roads that he uses when he gets a license. Everybody's better off. The alternative is, and this is where I think the tough decision for a court is the court would very justifiably say, well, I know how to make society safe for at least the next 18 months, 100%. Because if he's sitting in the Michigan Department of Corrections, guess where he's not? He's not in a car driving around killing somebody. And that's a good argument. But that doesn't solve the problem. Because the problem doesn't occur until or if Mr. McCombie decides that he no longer wants to be sober. And that's why I think a probationary sentence with monitoring in the community makes a lot of sense. If he's to fail, he'll fail in the next 2 years. If he's to really succeed and get cemented in sobriety, that'll also happen in the next 2 years. If the court sends to the Michigan Department of Corrections, this solves Sheboygan County's problems for a while, but not forever. Now, potentially, he could go to the Michigan Department of Corrections, and he could get counseling there, and he could stay on a good track. But I think the better option, in my opinion, is to let him stay in the community, let him stay doing what he's doing. Now, I know there's gonna be a break in it. There has to be a break because he has to go to jail. There's no scenario today where I can make it you an argument, a colorful argument that's consistent with the law to say he doesn't go to jail, because he does. It's just for how long. And the guidelines 0 to 6, advisory only, post Lockridge. The guidelines are a tool, but I think really, and I know you do this, Judge. I really do. I know you weigh these decisions because you have another master serve. You have the people who live in this community, who live in all these communities. You preside over court of general jurisdiction. Your responsibility is everybody in the state of Michigan to keep them as safe as possible. I'm asking you to give Mr. McCombie a chance, not based on the fact that he's a nice guy, not based on the fact that, you know, he says good things, not based on the fact that he does a couple classes, based on the fact that everybody has a point in their life where change is necessary and has to happen. I think Mr. McCombie has come to that crossroads, and maybe he's been there before. Maybe he's been there with direction of the court. Maybe he's been there with direction of people in his life. When he called me and said he was ready, without a doubt, and without hesitation, I said, go. You're ready right now, go. Because I don't want to wait for tomorrow. I know you're ready to go right now. And in sort of an edifying way, Mr. McCombie, I think, proved the advice that I gave him to be the correct advice. Because he didn't just go and sit as an empty suit in a classroom or in a counseling session. He excelled. He did well. He is continuing to live that life. As long as he lives that life, all the concerns that this court has about public safety, all the concerns that Ms. Goodrich has about public safety can be allayed. Probationary supervision with testing, whatever the court wants him to do, will also help him in those endeavors. I know he's got a long history. I know he's had a lot of chances, but this is my time to stand in front of this court and say, I think that the risk has been mitigated enough with the work that he's done to this point to at least say, let's give him a shot to see if he's sincere, but monitor him closely. That's what I'm asking the court to do. He's got to serve the 30 days. I think a sentence within the guidelines is warranted. There's nothing that I'm reading in the guidelines that isn't accounted for, given proper weight. So that's my 2 cents on it. I certainly doubt the court has any questions for me. I would answer the court's questions if you have any, but I think I've covered everything I needed to.
All right, thank you, Mr. Clay. Mr. McCombie, you don't have to tell me anything today, but you're welcome to. Is there anything you want to tell me or no?
I'm sorry I got myself into this situation and let people down, myself down, but I'm trying to do my best to make it better.
Thank you, Mr. McCombie. Ms. Goodrich, recommendations from people.
Thank you, Your Honor. I think it's important in this case to go into a little more detail about how we got here. On September 11th of 2024, which is a Wednesday at 7:07 p.m., law enforcement observed the defendant driving his vehicle on the wrong side of the M27 highway. He continued to drive erratically, almost colliding with another vehicle. Law enforcement approached the vehicle and observed that the defendant had urinated himself. The defendant had the car in reverse, so law enforcement instructed him to put it in park. Defendant complied with that. Then defendant put it in drive. Law enforcement instructed defendant to take the keys out 3 times and then had to reach over and do it himself because the defendant would not comply. The defendant was ordered out of the vehicle and the defendant grabbed a can of duster and began inhaling it right there in front of the officer sitting behind the wheel. Defendant then tried to grab the keys, but law enforcement fortunately took them away from him. The defendant then, with no keys, tried to put the car in gear, so law enforcement had to pull the defendant out of the vehicle. The defendant again tried to inhale more of the can of duster. Law enforcement had to continue to struggle with the defendant for about 1:40 before handcuffs could be placed on him. The lab reports revealed that the defendant had gabapentin, tramadol, and the inhalant in his system. The defendant is 50 years old. He was 23 at the time of his first arrest. He has a GED. He has 1 prior felony and 6 misdemeanors. They're all substance abuse related. The first OWI was in 1999. He received 1 day in jail. Again in 2000, he received an impaired 1 day in jail. In 2001, a drunk driving third, 270 days in jail. In 2021, another OWI third. He participated in our Sheboygan Recovery Court program, graduated in January of 2023 after 2 years of intensive probation, and turned around in January of 2024 and entered a plea to attempted chemical agent prohibited use. No jail. And then here we are in September of 2024. He's been in jail 3 times, probation 3 times, outpatient counseling 3 times, completed 2 inpatient treatment programs, as outlined in the PSI, completed the 2-year intensive recovery court program. The recommendation is for 6 months jail with 2 years probation. But based on all the efforts made thus far with defendant, probation just doesn't make sense. He knows what to do. He knows the resources that are in our community and chooses to endanger the public instead. I think the guidelines do not take into consideration the seriousness of the defendant's actions and choices on the date of the incident, which created a high risk of public safety. The guidelines do not take into consideration the fact he keeps committing the same crime over and over again, despite the large amount of time and resources that have been invested in him, trying to help him to stop. The guidelines do not take into consideration that approximately 1 year after he graduates from an intensive treatment court program, he is back on the road, driving while intoxicated. Defendant has exhibited by his decisions and actions that he just does not want to stop driving intoxicated. He doesn't become intoxicated and just not drive. He keeps choosing to get behind the wheel of the vehicle. Defendant has been given numerous chances to change his life and has not used them, but he has not been to prison yet. I'm asking the court to order 16 months incarceration. Thank you.
Thank you, Mr. McCombie. If you please stand for the first sentence. As you can tell from what your attorney said and what the prosecutor said, there's a lot of thought on both sides that have gone into this case. I've wrestled a lot with what to do about this, Mr. McCombie. You graduated from our recovery court program in 2023. So, that time, this is your true 5th impaired driving conviction. That was your true 4th, and you avoided jail or prison by a treatment court program. And then, I agree with almost everything that your attorney said here today, with one exception. And he said, well, we'll know in the next 2 years, but we gave you a 2-year recovery court program, and you graduated from that. We had a nice happy day that day, and And then you went out and very soon after shifted from alcohol into inhalants. I think, as you know, if you go back to alcohol, your body will kill you. You were on death's door from alcohol. I'm sorry that during the treatment court process, we didn't get deep enough to whatever's driving you to use whatever's in your reach. Like I said, your body has shut you down from alcohol physically. But clearly there's something still going on underneath that's, not allowing you to move forward with your recovery. What makes me most sad is that there was a vacancy in the district court when you got that huffing case. So I was your judge on that huffing case. And so there I was at sentencing on a misdemeanor for fines and costs under the criminal justice reforms. That's really what was called for that. But I remember talking to you about how you graduated from the program, how we were all invested in your recovery and your success in that. And I implored you to go upstairs and see Nicole, our recovery court coordinator, and get going in treatment. You didn't do that. That was another off ramp for you. You didn't do that. So although I agree with much of what your attorney said, I also agree with a lot of things the prosecutor said. And I had some notes to myself. I mean, this was a very dangerous impaired driving case. 7 p.m., you're crossing the center line. You're almost causing a collision. You're trying to put the car in gear while the officer's standing there. The public's at a heightened risk of death or injury. The officer's at heightened risk of death or injury with an impaired driver trying to place a vehicle in gear while they're doing a traffic stop. This is your true 5th impaired driving conviction. We've given you every prior intervention we can think of, including a treatment court. That's the best we have to offer. And then after that, you had another substance use conviction, and you disregarded the efforts to get you into treatment through that. Guidelines don't take into account the pattern of impaired driving here. They don't take into account the prior real rehabilitative efforts that were made. I think taking all those things into account, there's a crime victims assessment of $130, court costs of $350, $225 OUIL reimbursement, $118 in state cost. On the charge of operating while intoxicated, third offense, I find that the guidelines of 0 to 6 do not adequately take into account what I've described, and that a sentence of 16 months is proportionate, more proportionate than the guidelines range, proportionate to the circumstances, the seriousness of the offense and the offender, given the extensive impaired driving history and the prior rehabilitative efforts. So I'll commit you to the Michigan Department of Corrections for not less than 16 months, no more than 5 years, with credit for 2 days previously served. On the attempt RNO, it'll be 1 year in jail, credit for 2 days served. That'll run concurrent, so you'll serve that while in the Department of Corrections. You can file an appeal if you wish. To appeal from the conviction of the sentence or both. Going to hand you a piece of paper explaining that process. If you want a lawyer appointed, you have to ask within 16 months or within 6 months of today's date. We're going to ask you to initial one copy for us, and the other one is for you to fill out if you wish to take an appeal. Good luck to you, Jason. Do you have a copy of that? Well, Mr. Klein, if you just want to touch base with Agent Martin on your way out.
Okay.
See, the bailiff doesn't need that.
Okay.
But if you want to make sure Agent Martin has it, and Agent Martin, can you, she's in the jury box, so if you want to